My name is Goldman. I'm the Director of Prenup of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. There is a very interesting movie, a George Clooney movie called Bonfire of the Vanities. It's a movie that talks about matters legal and particularly family law, and particularly in family law, prenuptial agreements. What does a prenuptial agreement really do? And is it ironclad? In Hollywood, in the movie, they had this seemingly ironclad prenuptial agreement. The movie talked about how people were trying to get around it, what the impact of it was, and blah, blah, blah. In reality, in the state of Michigan, though, prenuptial agreements mean something different. You have to understand that, as a general rule, there is no ironclad prenuptial agreement in that here in Michigan, the court can always decide to either not enforce the prenuptial agreement or enforce parts of it, but not enforce others as justice requires. The court, as a function of its powers of equity, can determine that the prenuptial agreement is completely invalid, or that the presumptions that the prenuptial agreement was based on, that those presumptions no longer exist. It can invade the agreement, it can separate the agreement, it can bifurcate the agreement, it can do all sorts of things. So we really don't have a prenuptial agreement that is ironclad from as far as the meaning of those words go. Now, it is a contract. A prenuptial agreement is a contract that the court will try to enforce, just like any other contract where there's a meeting of the minds and the court is basically going to say, okay, you agree to this, you agree to that. If there was no fraud, no undue influence and all that, the court will try to enforce it as equity requires. However, you got to understand that if you're going into a marriage thinking, I don't have to worry, I'm protected by a prenuptial, may or may not be the case. Your understanding of your protection may represent an overestimation in the power of that agreement, because more powerful than the agreement is the judge who decides to interpret your life and your facts and your agreement and decide what works for what. So I've seen, for example, prenuptial agreements that talk about certain property and talk about growth in property. Sometimes the court will say, okay, this property was yours from before, it's still yours. However, the prenuptial agreement says that you get all the increased value of that property. We're not doing that. For reasons of equity. Maybe your spouse during the marriage became disabled, and therefore we've got to give her something else or give him something else, and if we honor the letter of the prenuptial agreement, there'll be nothing to give. So in that situation, the court could say how long the marriage was and come up with some equitable calculation to figure out how do we take care of the other person. So the court has the ability to do that. My message, therefore, is a prenuptial agreement is a good thing. It sets forth certain parameters. If done properly, it tells the parties what they're giving up and what the values are of the properties and what will be prior acquired and what will be the impact of growth of prior acquired property. And in that sense, it really sets forth for everybody a proper expectation. But understand one thing. Life has a way of interfering with those things that you may predict years before on the first day of your marriage. Life has a way of getting in the middle, and that's where the courts pick up. And the court may look at your life and what's going on and how the whole thing evolved and how long the marriage was, and may decide to do something that is not necessarily consistent with the words, the four corners, the actual verbiage of your prenuptial agreement. If you have any questions about that, reach out. We'll be glad to help you out.